If I find myself in one of these disputes, not knowing what to do, but have an arbitration clause in the contract, is there any way out of that?
Generally, the answer, unfortunately, is going to be no. But I will tell you, there are certain occasions where you actually do have some options. That's where you're going to want to get a lawyer, talk to them, have them read that agreement very carefully. There are a couple of ways that it can come into play. One is if the agreement is so one-sided that any judge or court looking at it would say that's just not a fair agreement. As in the case with Gretchen Carlson, you may not be able to sue your employer, but there may be other entities, whether it's an individual corporate executive, individual employee, or related corporate entity. You may be able to get out of your arbitration agreement that way.
Do you find that most people who come to you and say, Eric, help me, don't even realize they signed this paperwork and what it meant?
Absolutely. I mean, look, you're getting a job, you're excited, you're happy. They put a piece of paper in front of you and say, if you want the job, you need to sign this. Probably 10 pages, agreement, and somewhere inserted in there is some boilerplate language and legal jargon that says you're giving up your right to go to court. Now you're going into this confidential private arbitration. So yeah, most of the time they have no idea they've even signed it. And frankly, if they did know, they still want the job. So they're going to sign it. And that's why it's often referred to as forced arbitration.
What do you think is the first, second, and third things people should do to build their case arbitration-wise?
That, I think there's going to be a lot of similarities towards, the same way you'd want to build the strongest case possible for court. And so first and foremost, you tell the truth. Your credibility, whether it's in court or in arbitration, is the key, especially in a sexual harassment case where it's often going to be your word against the employer's word. Second thing is, if you've got some emails, if you've got some texts, if you've got some internal memos, make sure that you have a copy of those. I always advise my clients to be extremely careful and really consult with an attorney to make sure you're not taking proprietary or confidential documents that get you in trouble down the line. The third thing I'd say is have your lawyer, once you talk with them and once they know you're bringing a claim, make sure your lawyer gets in touch with the company and says, hey, you guys need to preserve all the evidence that might be related to this claim. Your best shot. If you're going into arbitration, you got to take your best shot there. You can't count on an appeal.